If there are topics that you think the center hasn't covered and should, we're open to your feedback. We are doing a lot of research, and we have articles to write, and we have programs to do and speakers to invite. So this is an opportunity for you to reach out to us with suggestions and for us to share what we think is important and cutting edge. All right. With that in mind, you do have your handouts with the bios of our speakers. And we thought that we would give Atreya Mathur the first panel of opportunity to speak about AI and copyright. It seems pretty safe, as if AI is safe. And there's a lot going on in 2025, 2024. So Atreya, please, if you don't mind, we would love to hear from you about what's new in AI and art law.
Of course, will do. And I'm just going to quickly share my screen. So hopefully you are able to see that okay?
Perfect.
Yeah, wonderful. Well, hello, everybody. Really excited to be here and very excited to jump in on the discussion. I will be talking a little bit about AI, art, and copyright, and mainly giving you a lot of questions and different issues and challenges that we're seeing and recent developments for you to consider. So hopefully we'll have lots to discuss very soon. But I thought that maybe I would let you know that we are seeing so many updates, and just in the last few months, weeks, days, there have been so many more advancements with the AI technology and from the innovation aspect than there have been decisions and rulings from courts. So it's probably important to keep that in mind, that AI is developing at a much faster pace than we're hearing any legal concerns being addressed. And also taking that into consideration, it's important to kind of understand things from, yes, a legal perspective, but also understanding the ethical considerations that seem to be very critical for these discussions. And not only viewing it from a lawyer's perspective, but also from an artist's perspective, an engineer's perspective, and very importantly, from a user's perspective too. So I thought that I would let you know a couple of examples. In my room right now in the background, I actually had generated 2 AI pieces back in 2022. And I was testing it out, and I was so curious to use different prompts and find something that would match my aesthetic, match my room. And I finally was able to iterate these text prompts that were perfect. And I actually ended up printing them out on canvas and hanging them in my room. And I thought that, oh my goodness, did I create these? Are these mine? When people come over, they ask, oh, did you paint this? And I always say that no, but it really feels like I participated and I made them. And the images that you see on screen as well, very contentious, can be a very contentious topic for people to discuss. But these were also generated by Meta AI, by Llama AI. And once again, you have access to my PowerPoint. You're able to see this on your screen right now as we speak. So you have access to it. But are these my images because I generated them? Are the ones that are hanging in the back, if someone comes to my apartment and takes photos of them, are they taking photos of my work, of my copyright? And in the images you see on screen right now, once again, I try to include the artwork of some artists, some semi-popular artists like Van Gogh, to see, could I incorporate their art in my AI generations as well? And a lot of the work that you see is slightly familiar. And you have the Starry Night, you have some flowers as well that will look familiar to you. And I guess, is this legal? Is this ethical? Is this right of me to include the work of other artists in these kind of images? So these are some of the questions that arise and that we'll kind of be talking through, and hopefully you'll have lots of questions by the end of the session. But I thought a good way to really get into it is to show how people are creating with artificial intelligence and what kind of technology is being developed. Also from a bit of the art market perspective too. I'm not sure of how many of you are familiar with IDA. And IDA is actually a humanoid robot, and it draws with the hands, and it's a combination of using a bunch of cameras in the eyes. It has AI algorithms, and it has a robotic arm. And you can see Ida in the image over here. And Ida is actually named after Ada Lovelace, who was the first computer programmer. And what Ida did is that it created a portrait of Alan Turing, which is also very fitting, as Alan Turing, of course, is a computer scientist, and he was one of the first people to discuss artificial intelligence. So Ida had created this piece of Alan Turing. It's called AI God, and it was estimated to sell at Sotheby's at an auction for somewhere between 120,000 to 180,000, but ultimately it sold for $1.08 million. And this was after, I think there were 27 bids. And we are seeing AI generated artwork, whether it's being generated on platforms like OpenAI or ChatGPT, or made by AI robots using AI algorithms, and it is selling for money. So while of course we are curious about who owns the work, who owns the copyright, you did have a private buyer, a collector for this work. But a more concerning question is also, do people care? Does copyright matter if these collectors and people are willing to purchase this artwork as more of a statement piece? Then does copyright matter in this context for AI generated art? So these are all very, very concerning and interesting issues to think about. But some of the things that we will get through is, who is the author of a work, of an AI generated work? Who's the owner of it? Who has rights to it? And if a human is collaborating with artificial intelligence to produce something or create something, can that ever receive copyright protection as well? And these are one set of issues, but on the other end, you also have to think about the actual output that's being created. So the output, when you finally see that final image, the images I showed you over here, or the ones in the background in my room, when you finally see those, are those infringing of other people's artwork? How are these AI platforms and softwares fed in information? How is it learning to produce the work that it is? Is this infringement of pre-existing work, or is it transformative? Is it fair use or fair dealing? Is it changing the work and adding something to it? Like Ida commenting on the future of artificial intelligence in the context of art with the portrait of Alan Turing. There are also a lot of other questions about creating in the likeness of an artist and racial bias in training, which we may not be able to get to, but these are just a couple of things to keep in mind. And while I'm not going to go into the details of copyright, I guess with this discussion, you should keep in mind that copyright, it's a form of intellectual property. It's a creation of the mind. And the reason why I keep talking about it and everybody is so invested in this, you might be thinking that why do we care so much of if somebody has copyright over a work or not? It's because with copyright, you have a certain set of exclusive rights to reproduce, publish, create derivatives of a work. And you no longer have to be starving to be an artist, right? You have independence right, you have independent rights, you have economic rights. And along with this, there's a certain balance that has to be drawn according to the Constitution of the US, that while you do have economic rights for work that you create in the intellectual property clause of the Constitution, you also have to give enough leeway for innovation, and you have to be able to foster creativity, and you have to also have to foster that creativity for the progress of science and useful arts. So you see that there's some kind of a balance that needs to be drawn between protecting the work of artists and advocating for to ensure that artists receive the economic rights, but to ensure that it doesn't hinder that type of creativity and innovation. So the first set of issues, and a very good example to start us off with this, is copyright registration with Zarya of the Dawn. So how we're able to understand a lot of what is happening now is by understanding one of the first registrations. And Zarya of the Dawn, it's a graphic novel, it's a comic, and it has text and it has images. Now, the human artist Chris Casanova had written the text, and then she had used Midjourney, an AI platform, to generate these images. And initially, this received copyright protection for its entirety. The graphic novel received it. But afterwards, the Copyright Office learned that the images were created by artificial intelligence, and it rescinded the protection for the entire work, but it retained protection over the selection and arrangement of the graphics and the text together, but only to the extent of the human authored components. So this was a very, very important registration because we finally received guidelines from the Copyright Office stating that in order for a work to receive protection, one, the author has to be human. And if the traditional elements of authorship, if the substance of the work has been generated by AI, by artificial intelligence, then it's not going to be enough. So if you simply enter a text prompt and you let the AI generate the image, like what I had done, I didn't know how the images were going to turn out at all. It was doing its thing and those works were being produced. And that is not enough creative control by a human user. So that is not going to be enough to receive copyright protection. And also, it is going to be decided on a case-by-case basis. But if there's enough of the human authored component, then the work could be protected as a selection and arrangement. But once again, only to the extent of the human elements that have been added. Now, there are a lot of questions that arise just from that, right? That how much human creativity do you need in order for copyright protection to subsist in a work when a human is also authoring that work? Now, theater geospatial is another really good example. You have the blurry image you see on the left-hand side. This was generated by Midjourney by Jason Allen, who was the artist. He used over 8,000 text prompts to generate that image. And after he generated that image, he added all the additions you see on the right-hand side, details to the figures, texture, art to the walls. But what the Copyright Office stated is that that is not enough human creativity and control. The substance of the work is generated by artificial intelligence. And the sweat of the brow doctrine under copyright, when you put effort and labor into something, you could receive protection, but that doctrine has been done away with. So just because you put in 1,000 text prompts in order to generate this image, that doesn't mean that you're going to get copyright protection to it. It still has to satisfy the originality criteria. It has to be fixed in a tangible medium of expression, and it needs to have that originality and modicum of creativity. Now, to switch things up a little, Colleen Hoffenbacher, a wonderful artist, I had the pleasure of speaking with her, and she was influenced by works that were generated by AI. So on the top left hand of the screen, you see two images. And what Colleen Hoffenbacher did is that she was inspired by those images, and she painted these flowers using oil pastels, colors, and aluminum foil on canvas. And of course, that was created by a human, it's traditional authorship, and that received copyright protection. So anything that is solely generated by artificial intelligence is not being protected. Whatever is being generated, it's kind of in the public domain and free for all. So the images that I showed you at the beginning, technically I don't have any protection to them. And I'd be very sad, but you could print them and you could sell them and you could put them on tote bags. But as of now, anything that's solely generated by AI, no matter how many text prompts you put in, is not protected. And that's what the Copyright Office has continued to reiterate in its very recent March 2025 report, giving a lot of these examples of cases that we have seen, that just because it's generated by AI, not protected, there has to be enough human component and creativity and mental conception in order to receive that work. Now, the other half of the discussion is on fair use and infringement. And a really good example of this that I recommend reading the case of Sarah Anderson versus Stability AI Midjourney. There was a class action filed against a number of these AI platforms, and Kelly McKernan, she was one of the artists, and I had the chance to speak with her as well, and she was initially very excited to collaborate with OpenAI, but she got a comment on Instagram saying, I love your work here, but it wasn't hers. And that's when she got very, very cautious that the ideas she had in mind and the series of artworks that she had been working on had been copied, and AI was just reproducing all of this artwork in her style. And unfortunately, her claims in this case were dismissed because her work wasn't registered under copyright. So that is something important to note in the US. If your work is not registered with the Copyright Office, then you are unfortunately not going to be able to file a lawsuit in federal court. A couple of other issues, because I know I am short on time already, is recently there was a trend of generating artwork in the style of Ghibli, which is a Japanese animation studio. And a whole other discussion to get into is whether style can be protected or should be protected. And under copyright, one of the main concerns, as I was talking about earlier, the Constitution balances economic rights with fostering creativity and innovation. So style is generally not protected because otherwise you'll have an artist who can solely create anime or create another genre of artwork. So it's very difficult to kind of protect that style and protect artists in that context. A couple of cases I would recommend reading, I know I'm out of time, is New York Times versus OpenAI and Thomson Reuters versus Ross Intelligence. And both of these are cases where information has been fed into the AI system and work has been regurgitated. And very recently, we heard from Reuters versus Ross Intelligence that it is not fair use if work is being data scraped, and then it's not transformative if it's regurgitating and finding the same cases. So I wish I could go into the details of this, but a big distinction between these cases is that New York Times dealt with a generative AI where ChatGPT and OpenAI Midjourney, they're producing new materials. But the other case, Routers versus Ross Intelligence, it dealt with non-generative AI. So you're researching something that already exists. So that's a big distinction to make, but the court held that it was not fair use. And it is on interlocutory appeal right now, but those are very, very important cases to follow. There are also various jurisdictional issues that we're seeing across countries about whether these cases can also be heard in different jurisdictions in different countries. And OpenAI had made a claim saying that, we can't, we can't battle this case in India because there are no servers. But the court said that Facebook, WhatsApp, Twitter, they don't have servers in India, but they have to comply with Indian law as well because they provide certain services. So follow these cases. I think they give a good backdrop of some of the issues. The way forward, it does seem like AI is here to stay. So an ethical, collaborative approach should really be considered at this point in the best interests of artists and what can be done to protect them. But as I keep mentioning, because technology is developing so much faster than we're hearing any court cases and we're getting guidance from courts, there have been a lot of updates to what artists are doing. And University of Chicago, I'll quickly mention this, and it's great to look at. They introduced two tools, Nightshade and Glaze. Nightshade, it's a data poisoning tool. And very quickly, what it does is that it poisons the data, the pixels. So while it doesn't look any different to the human eye, when a work has been poisoned with a nightshade, if you have an image of a dog, it tricks the algorithm into thinking it's a cat. So the same subject matter can never be copied. And very importantly, similarly for glaze, it prevents mimicry of style. So as I said, style isn't something that's protected under copyright. And Kelly McKernan, her claims had been thrown out by the court because her work wasn't registered. So what she did is that she glazed her work. And what glaze does, similar to Nightshade, it prevents a style from being copied. So if you have an impressionist work, then you can glaze it to make it look like an abstract work. And this is something that she had done to make her glazed image look like a skeleton and a skull. And this has been a couple of the initiatives that artists are doing at their end. And I guess to finally conclude, I'll just say that, you have the work that has been created by Ida, the humanoid robot, this portrait of Alan Turing that sold for $1.08 million. And then you have a banana duct taped to a wall that sold for $6.2 million. And I guess we're still trying to figure out what is art, what is the scope of the protection, and whether copying certain elements or parts of this would be infringement, and whether these works should be granted copyright protection in a traditional sense. So I will stop there. I'm sorry, I know I went a few minutes over time, but there was a lot to cover. And I hope that these give a good good examples of some of the issues that we're seeing. And I wish I could give more answers, but we're still waiting to hear from so many courts, so many cases, and it should be interesting to hear what happens this year with the New York Times case, with the routers case, and to see how artists are kind of taking a lot of actions and steps at their own end to protect their work when the law isn't able to catch up to all the advancements in technology. So thank you, and happy to answer any questions.
Thank you, sir. I think we will hold the questions until everybody gets to present. Thank you very much for the updates. There are many news coming in this field from the United States. There are cases that you, audience online, or you audience in the room would like to share about the UK, if there's anything going on, or other jurisdictions, it would be terrific. So as you're thinking of questions for Threya, maybe you'll have some questions or additions to recommend. Before I turn your attention to a different, not intellectual property, but actual tangible property and economic rights that are affected in connection to art collecting, I do want to mention a couple of things. The center is very much in business of hoarding information, but we don't just hoard, we share it. We have lots of different databases. Some are stronger, some are in under construction. One of them is not the art restitution cases, and many of our volunteers and team members and students have been working on this database. We had a conference in New York in April dedicated to the subject of Nazi eluded art, and if you're interested in it, there is an update out of Chicago as well, as coincidentally. The museum, the Art Institute of Chicago, was ordered last week, still Monday, right? Last week, to turn over a painting by Schiller, Russian war prisoner, that has been the subject of a very interesting and prolonged litigation. You may have different feelings about the set of circumstances presented to the court, but it's an interesting, long 79 pages decision why the work of art needs to be handed to the heirs of Prince Brusco. So if you, yes, Bruno, if you are interested in seeing this case or other cases that we are monitoring, please let us know. But it's a big decision, Nazi eluded art subject matter. And in general, the cases that we are pinning, copyright and others, can be found in the case law corner. I'm not logged in, so I'm not going to be able to show you very quickly that resource. And the Nazi eluded art restitution database and gleaned on our page. We are working very hard to visualize this information in 21st century way. So we'll have interactive data, interactive timelines, and interactive data sets. All right. So with that in mind, the next speaker is actually from Fieldfisher, and we're really, really grateful to be here, and we're very grateful to hear from Alice Swink, who is she's a partner. She's an expert on tax law, which is, I think, the hardest of them all, frankly. And Alice will speak about collecting and what collectors should keep in mind when they are handling art.
Absolutely, and thank you for that very kind introduction. It's a pleasure to welcome you all here to Fieldfisher, and hello to everybody online. Great to meet you. So as has been mentioned, I'm a tax lawyer. I specialise in advising individuals, family offices, trusts, personal companies, governments, who else? Charities, a really broad range of clients on UK tax and the implications arising from UK tax issues. Now that doesn't mean that I just talk about dry tax all the time. Quite often what I'm talking about with clients is succession, transferring assets, moving assets around the world. The vast majority of my clients have got at least, well, maybe a toe in the UK, with the rest of the foot being very much outside the UK. So it's a real key focus of my practice is clients who are multinational. And clients who are multinational, as we know, are the sorts of people who are interested in buying art and moving their art from place to place. So what I wanted to do today was to give you a very brief update on quite a, well, it's a huge subject, and I could talk about it for hours, but I won't do that because I don't want you all to fall asleep. Which is the most recent changes to the UK's tax regime. So I would say that the changes that came into effect on 6 April, so they're not even a month old yet, are probably some of the biggest, if not the biggest, in the years I've been practicing, if not for the last half century. And what it means is it's sort of the key headlines for clients, and I'll go through what's changed and why it matters in a moment. But the key takeaways for my clients or for people that you're interacting with who are collectors of art is this is a really key opportunity to revisit how art's being held, whether or not it falls within particular rules that I'll go through in a moment, and whether there are steps that need to be taken in the short term to make sure that clients are being as tax efficient as possible. So here in the UK, we've had for centuries, we've had the concept of domicile in our tax legislation. And domicile has always meant something slightly different in the UK from other jurisdictions. And domicile has never been defined in statute. It's something that exists in case law and in common law. And domicile, the best way I can describe it is the concept of home. Where do you feel your home to be? So if I move to Paris to do some work in Paris, I've been born in England, I've lived in England my whole life. My domicile, the place I call home, would still be England, even if I am tax resident in France. And the same is true for somebody moving to the UK. And domicile can be changed, or could be changed, as can no longer, because it no longer exists from a tax perspective. But you could change your domicile by moving somewhere else as an adult, moving somewhere else with the intention to remain there permanently or indefinitely. And we had in the UK a beneficial tax regime for people who were UK resident, but not UK domiciled. So the inverse to what I've just talked about, somebody moving from France to the UK, becoming tax resident in the UK. And what that beneficial regime said was, for me, as somebody who is both UK resident and domiciled, I pay my tax, my income tax and my capital gains tax in the year in which I make some income or I make some gains. Very simple. And it doesn't matter whether I make that income in Spain or in Hungary or in the UK. I have to pay tax on it in the year it arises. For somebody who was a UK resident but not UK domiciled, we had a regime called the remittance basis. And what the remittance basis did was that people who were not UK domiciled could elect that any non-UK income and gains, provided they kept them outside the UK, were not subject to UK tax, even though they were UK tax resident. And that regime was very attractive to a lot of people moving to the UK, and it had limits. So you could, for the first 7 years, you could access it for free. For the next period, you had to pay, so up until 12 years, you had to pay a £30,000 charge per year to access it. And between 12 and 15 years, it was £60,000 a year. And after you've been UK tax resident for 15 of the previous 20 years, it didn't exist. It was gone. And then, just like me, paying UK tax on income and gains as it arises. And the remittance basis has been a really big political hot potato for quite a long period of time. Successive governments have talked about it, and it all came to a bit of a head with Rishi Sunak's wife. Because Rishi Sunak's wife, our previous Prime Minister in the UK, was a non-dom, and she had claimed the remittance basis legitimately. She had accessed the regime that was available to her as a non-dom. Problem is, she comes from a very wealthy Indian family. And of course, our newspapers got hold of it. There was a lot of press around her not paying her fair share. I won't go into the level of journalism, but you can imagine it wasn't particularly great. Made a fantastic headline. Here were politicians and their wives allegedly not paying the right amount of tax. So the previous Conservative government talked a lot about doing something about it. And they came up with some proposals in spring last year, where they put forward a whole raft of changes that they were going to make. We then had an election over the summer, which saw the Tory government be booted out of office and the Labour government that we currently have step into their shoes. And what the Labour government did, and I apologise for this bit of history, I will get to the tax point in a moment. What the Labour Party did was take those proposals that had been put forward by the Tory party in the spring and turn those into what then became the autumn budget on the 30th of October 2024. And the key things that came out of that was a real focus on this concept of domicile, with the result that, with effect from 6 April 2025, domicile does not exist. And what that means is the remittance basis that I've already talked about, that beneficial regime for people who are UK resident but not domiciled, no longer exists. What we have instead is we have a very short window now in the UK for new arrivals. The first 4 years of somebody being in the UK, provided they haven't been UK resident in any of the previous 10 years before they arrive, first 4 years, any non-UK source income and gains will not be subject to UK tax. So that's a window to remember. After that, they'll be subject to UK income tax and capital gains tax on their worldwide income and gains, just like me. The other thing that domicile was relevant for was our inheritance tax, our estate tax. And our inheritance tax, which is has taxed at a rate of 40% on death, applied to UK domiciled individuals on their worldwide assets, and UK and non-UK domiciled individuals only on their UK sited assets until that same 15 out of 20 years of residence, at which point everything worldwide estate was within UK tax. This is of course subject to double tax treaties with other jurisdictions. I do quite a lot of work with clients who are UK and US citers, so a lot of my planning is making sure, for example, that the UK-US double tax treaty for estate planning works well for both jurisdictions. So in getting rid of domicile for the remittance basis, they've also had to get rid of it for inheritance tax. What that means now is that anybody who has been UK tax resident, so we're now looking at residents again for inheritance tax resident for 10 of the previous 20 years will be subject to inheritance tax on their worldwide estate. And that's probably the bit that's got people most up in arms. My clients in general don't mind paying a bit of income tax, a bit of capital gains tax. They think that's fair. What they do object to is suddenly being within the scope of inheritance tax for the entirety of their worldwide wealth. And what does that mean for collectors? What does that mean for people who have built up a really beautiful selection of artwork both in the UK and outside the UK? Well, for those who have previously been remittance basis users, so who were UK resident but not domiciled, then if they've got assets, if they've got art that they bought outside the UK using non-UK source income and gains, they still need to be really careful about bringing that art into the UK, because that element of the remittance basis hasn't been switched off. In effect, if they bought something in France using non-UK source income and gains, and they now bring it to the UK revenue will treat them as having brought in that previously untaxed non-UK income or gains. there is a window this tax year, next tax year, and the following tax year in which there is a beneficial tax rate that can be accessed by somebody who wants to bring that art into the UK. So if there are collectors that you know who are thinking about moving things into the UK, using this window is a really great opportunity to reduce the tax bill. And by how the level of reduction is significant. So there is a flat tax on those income and gains being brought to the UK in this year and next year of 12%, of the following year 15%. Otherwise, it's a maximum of 24% on capital gains, 45% on income. So that's historic income and gains that are sort of rolled up within those assets held outside the UK. There is still merit in thinking about using non-UK structures, so trusts, corporate structures, foundations in jurisdictions that recognise foundations, Stiftungen, any other type of entity around the world that has previously been used for this type of planning. It's still worth considering. Particularly before somebody becomes long-term resident for inheritance tax purposes in the UK. So remember, that's the 10 out of previous 20 tax years. So looking at that in the round, there may still be opportunities for people to hold a collection within a structure so that it's protected for succession purposes, protected, the assets are protected from divorce, or so that the collection is housed in a way that it won't get broken up when somebody dies. There are one of the issues is the tax laws are so complex and so intermingled. We're still getting our heads around exactly what it means for each of the clients. So there are additional knock-on tax considerations in relation to trust structures. And I wanted to mention trust structures in particular because a lot of my clients have favoured using trust structures, particularly those who've have been in the UK because trusts are recognised here. They often use the Channel Islands, Jersey, Guernsey or Switzerland for their trustees. And the trust law element, the taxation of trusts has also been amended as part of this massive overhaul. In particular, there were a series of rules that were put in place in 2017 which protected income gains arising within the trust from being taxed on the settlor. And there was a series of rules that had to be followed. The trusts couldn't be tainted. Basically, the settlor couldn't settle any more into the trust. But provided those rules were followed, then that non-UK source income and gains rising within the trust, not a problem for the settlor. Those have been switched off. So any trust with a UK resident settlor, unless changes are made to that trust, will be looking at the settlor themselves, will be looking at UK income tax and capital gains tax on income and gains arising within the trust. Not only that, but if the settlor is a long-term resident, so within the IHT rules, the trust will fall within the IHT rules. And that in itself is a massive change because historically, the domicile of the settlor on settlement was the IHT determinant. And it never changed. Even if the settlor changed their domicile, the domicile of the trust remained the same. What has happened now is that the IHT status of a trust can change from time to time, depending on
Inheritance tax.
inheritance tax. Yes. Sorry, did I?
No, just in case.
Sorry, yes, IHT, inheritance tax. Yeah, too many three-letter acronyms. The IHT status of the trust can change from time to time depending on the IHT status of the settlor, and that can have a number of effects, but the most prominent are a trust that is within the UK's inheritance tax regime will be subject to regular charges to UK tax every 10 years. So there's a lot of change, and there's a lot of it's pretty vital at the moment for those who have been collecting art within a structure to really check that that structure still works well for them and is the best way to hold it. In some scenarios, it might be an opportunity to bring that structure to a close. It might be an opportunity to take things out and pass it down a generation. There are plenty of opportunities to make sure that I'm quite liberal in my views, but my personal view is everybody should pay the right amount of tax, and that means that if somebody is overpaying their tax, well, they should be taking steps to make sure that they're not. And if somebody is underpaying their tax, then they should be taking steps to make sure that they're paying more. So my key takeaways from this that I wanted to leave you with was check with clients what the structure is and whether it still works, and also check their testamentary plans. So do their wills, does their succession planning work in the way that they want it to? For clients to prepare, that's the sort of the next, or that goes hand in hand really. If clients are thinking about doing new things, holding art through a new structure or looking to acquire something in a different way, possibly using funds they've had sitting in a bank account for quite a long period of time, then take some advice to work out whether or not there could be UK tax implications around that. And then finally to act, particularly if you've got a client who or a collector who might be thinking about bringing art into the UK and might previously have been a remittance basis user, because we've got that very limited 3-year window in which to make sure that they pay a significantly lower amount of tax on those foreign incoming gains that have accrued to them. And that was all I was going to say on this particularly thorny issue. But I'm very happy to answer questions at the end.
I would just like to say thank you for that. And the department I was going to qualify into for litigation to deal with tax. So I actually do find tax quite interesting. But I just want to say thanks, Alice. And also, if anybody has any questions, we can share your email details, because obviously there's a lot to cover and it's too much to do so in the session.
Is there any chance I can dive in with one question? No. It's a conflicts of laws question. So if you've got artwork in a Cayman trust, for example, but if Cayman's a bad example because it has complicated laws, then pick any other country that might have a trust structure. If I'm going to say the UK, but perhaps it's England and Wales, thinks that this now falls within English IHT law, for example, but as a matter of Cayman law, it would fall within Cayman IHT law, or it's a Cayman. Let's imagine this hypothetical country, whatever it is, Cayman or somewhere else, has a concept of domicile which keeps those assets within their tax regime. What then do you do?
Practically, what I do is firstly I check to see whether there's a double tax treaty, which unfortunately there are not a huge number of double tax treaties dealing with estate or inheritance tax. And then there is an element there of somebody is going to have to file a return. Somebody is going to have to file a return to the UK revenue. And even if there is no double tax treaty, there is unilateral tax relief from double taxation. So what I would be looking at in that scenario, if I did have a situation where they both were trying to charge tax on the same event, and that I think is probably the nub of your question, is actually there are very few jurisdictions around the world that have a trust taxation regime that is like the UK's, and it is the UK's rather than England and Wales, because it applies equally to Scotland. If I had that scenario and I didn't have a double tax treaty, then I would probably be recommending that my trustees or my beneficiary, whoever it is who is subject to the tax liability, submit returns in both jurisdictions and make sure that both jurisdictions are married up in terms of what's being reported where, and that unilateral tax relief is being claimed, to make sure that overall it's the correct amount. And the way that unilateral relief generally works, and this is, I'm sorry, a bit of a simplification, but if I've got one country that pays that it's a 20% estate tax and one country where it's a 40% estate tax, then you might end up in a situation where you pay both countries 20%. So the higher one gets a bit less, but overall the sum is the same. The sum is the highest of either.
You can't elect the zero tax jurisdiction.
Not unless your double tax treaty says that it should be that jurisdiction that has primary taxing rights. But it would be, I have never come across a situation where a client has been able to elect out of UK tax voluntarily in that way.
They need as much as they.
Well, there is that. But it is a really interesting question when we're in a situation where we've got conflicting points of tax, and lots of clients are trying to navigate that really tricky path between having different tax requirements in different jurisdictions and who gets first bite of that particular cherry.
So from a commercial perspective, sometimes there are arguments, I don't know, made of where does the performance, where does the obligation arise, and how kind of then determine them. That's all very complicated subject.
All right. Let's stop for a second. I have this. You actually made it sound slightly simple. Slightly. Although I expect there are many new attorneys rushing to become tax experts.
That would be lovely. Please send them my way when you find them, because they haven't yet come knocking on my door. I think partly because it is a very it's a subject that takes a long time to become proficient at. So it's quite hard, I think, for our trainees when they come and sit with us and they sort of get all of these acronyms and section numbers and concepts thrown at them, and they have to sort of grab it and run with it. So, but hopefully, people come.
So for the students in the room and online, in my not expert opinion, I think tax is a very interesting and both lucrative field because there is a lot of work to be done.
Absolutely.
So as I mentioned, Rena was supposed to join us, and I know that she's online. I'm sorry she's not here to talk about the work that she does on due diligence for art market participants. We at the center are working. I hope all of you know already. A couple of years ago, we put out a comparative study of AML regulations inspired by the 5th EU directive. I know that we're already in the 6th EU directive staging plans. So the center is going to produce an updated 2nd edition to the study. I thought I was sharing my screen, but I wasn't. There we are. The first study, not ambitiously, wanted to have all EU members represented, and we're very grateful to have Noor work with the center to work on the French component of the study. It was very hard to get every jurisdiction included, but after producing the first edition of this comparative study, we were asked pretty much momentarily by attorneys from other countries, including Switzerland, saying, would you like to have chapters on other countries? And I thought, great, we definitely do. So we're in the process of working on the 2nd edition. We'll have Switzerland included. We have India included. There are a few other countries that are being redacted and edited. And Rakib Talwar, who is joining us online, she wrote the UK chapter, and she offered to be a guest editor for the 2nd edition to make sure that the materials are easy to compare across jurisdictions. And it's not tax law, but also quite a rigmarole to understand what kind of due diligence requirements exist for the art market participants. So with that, we may answer if you have questions or comments to make after Erin speaks. Do you want to say a few words?
I just wanted to say that the UK is not completely clear on this area, but it has the UK government has published guidance, and there is more stringent requirements for due diligence in the art sphere. Financial sanctions guidance for high value dealers and art market participants. So we can share that link. Ofsted doesn't prescribe specific duties, but it does require an extra level of due diligence to be undertaken. You're a high value art market dealer. So anyway, that guidance can be found online, and happy to share that as
And I
well.
think it's in
That's
it's
very
in the
recent.
handout. And that will be part of the UK scene starting May of 2025. And it will definitely be part of the updated study, which we hope to publish also sometime over the summer. All right, so the third speaker, we're very grateful to have with us, Aaron Taylor. He is a barrister and he teaches as well as litigates on various art law subjects. When we're trying to identify a particular set of what's new, there were a number of options, and Aaron offered to speak about import after the presentation on whether you want to bring your assets into the UK. What happens if you do want to bring your assets into UK?
Thank you. Yes, well, take them out the UK. I'm going to talk about Regulation 2019/880 of the European Parliament and Council on the introduction and import of cultural goods, which I'll say again in case anyone wants to get it up in front of them on a computer. Regulation EU 2019/880, and it concerns. This is I think a sort of seriously important. Somewhat new development in the world of art. It concerns the introduction /import, and those words have different meanings, into the EU of cultural goods. The reason it's a sort of new development now, even though it has the number 2019 in it, is because the self-imposed deadline for implementation is the 28th of June of this year. So all of this stuff, so long as the electronic system of administering it all is actually up and running by the 28th of June, which is, we'll see. So long as it is, then this will all come into force quite soon. It's a regulation, which means that it's directly effective in EU member states. It therefore isn't effective as a matter of UK domestic law. So this is of relevance to UK participants, UK market participants, insofar as they are seeking to export works of art or cultural heritage into the EU. So we are a third country, the same as the US or Brazil, for the purposes of the regulation. It does not involve, it does not bring within its scope objects which originated within the EU. So we'll see what sort of ills it's trying to target later, but think, for example, about things like looting of Cambodian architectural sites, looting of Palmyra, for example. But it doesn't involve Greek artifacts. It doesn't involve Roman artifacts, at least insofar as those things came within the territory of countries that are now within the scope of the EU. I suppose some of the broader reaches of the Greek and Roman empires weren't, but broadly speaking, those things aren't within scope. And this follows a trend, and we would have, I think, seen this trend particularly strongly from Brenna's talk, of the EU seeing the art market as a troublesome or at least potentially high risk industry, specifically in the field of cultural heritage, even more so than art, and seeing it as a field that needs regulation. And that's, we've seen that especially in the field of money laundering. And I think that can be contrasted with the approach in other countries. I mean, the obvious example now is a somewhat deregulatory approach coming from the current US administration. And there is, I think, an increasing divergence in the way the art market's seen. As perhaps people know, money laundering regulate the Bank Secrecy Act doesn't apply to the art market in the US, or it applies to antiquities, but not the art market. So we've got a sort of increasing level of divergence in what is regulated between the EU and sort of the US and perhaps even the rest of the world. Right. What is it? At a very high level, the purpose of the regulation is to prohibit the import into the EU of some things, and then to impose different levels of steps that have to be taken to import into the EU certain other things, depending on the level of risk associated. We'll go into what those things are. But I don't want to bury the lead. So to start with my assessment of things, I think the short point is it's a very well-intentioned regulation, but I see it as a case of using a chainsaw to open an avocado. It's just it's real overkill and ambiguity in lots of respects. We can get the intention from the preamble. And what's interesting about it, it reveals, even from what you can see on the screen, we get a sense of what is the menace that the regulation is trying to combat. So we see references to the illicit trade in cultural goods, their loss and destruction, the preservation of humanity's cultural heritage, the prevention of terrorist financing. Okay, I agree with all of those things in the sense that I agree that terrorism financing is bad, and I couldn't agree more about the importance of preserving cultural heritage. That still raises some questions. One of them is that the ill that's set out in the preamble properly evidenced? So when we talk about terrorism finance through the sale of illicit antiquities, has the Parliament and Council really checked the evidence whether there's of the extent to which there's actually a lot of studies or attempted studies about the extent to which terrorist groups are in fact raising money through cultural heritage, and it's broadly thought to be one of those problems that is frequently stated by newspapers but without any actual or with pretty limited evidence. To take another example, it's the fourth sentence of preamble number 3 says, pillaging of archaeological sites has always happened, but has now reached an industrial scale. Is it true? Where is the evidence, I would ask, that yes, it's always happened? Where is the evidence that it has now got worse? That might be true, it might not be true, but simply stating it as a matter of fact in preamble doesn't necessarily help. So I think there are definitely good intentions. Yes, we all want to prevent the destruction of cultural heritage. Yes, we all want to prevent the trade in cultural heritage, and certainly we all want to prevent money filtering through to terrorist groups involved in, like, let's say ISIS in Palmyra. But we need solutions which are properly focused on how precisely the problem is and precisely how it's coming about. Nonetheless, noting those things in the preamble, references to cultural heritage, references to terrorism finance, references to the UNESCO Convention, which I'll come back to, they show, I think, what is the menace that we're really focusing on. As I say, I think we should think of things like the looting of Iraq after the US invasion, destruction of Cambodian sites, Palmyra. These are the examples. And the reason I sort of dwell on that is because we'll see in a sec there's a category B of goods and a category C of goods. And those things that I've just talked about are the category B of goods, said to be high risk, which have a more onerous set of provisions and whatever. The category C set of goods is something very different. It's a much broader category of cultural objects. And they seem to me to be sort of set apart from the menace which is set out in the preamble. It seems like it's going to be a regulation about architectural sites and so on. And in fact, it's somewhat wider than that. And that, again, is, I think, it begs the question whether it's really necessary and appropriate for it to be so much broader in scope. Right. How it works. I'm really sorry. It's hard to talk about a regulation without reading the regulation. So strap in. The general prohibition is in Article 3 of the regulation, which it says simply the introduction of cultural goods, referred to in Part A of the Annex, and I'm afraid we're going to get to the Annex, which were removed from the territory of the country where they were created or discovered in breach of the laws and regulations of that country shall be prohibited. There's an absolute ban on the import into the EU of items which were illegally removed or illegally exported, if those are items listed in the Annex. So you can see the Annex if you've got it in front of you. Part A lists all of the relevant goods. I don't know if anyone's controlling if anyone is controlling the screen. Oh, that's very kind, thank you. And we have a long list. So we start with rare collections and specimens of fauna and flora, which seems quite, that's somewhat removed from where we started. Property relating to history, including the history of science, naval, military, so on. Products of archaeological excavations. Okay, we've got to where we thought we were going, or discoveries on land or underwater. Elements of artistic or historical monuments or archaeological sites which have been dismembered. Fair enough. Antiquities of more than 100 years old. Objects of ethnological interest, objects of artistic interest. Then we've got various subcategories like paintings, drawings, statuary, engravings, prints, so on. Rare manuscripts, old books, stamps, archives, furniture of more than 100 years old, and quote, old musical instruments. So already there's a couple of points for lawyers. We've got a whole load of undefined things there. What is an old musical instrument? When does one become old? What is somewhere we have maybe it comes later. We have the word important. What is an important object? How do we date certain objects, and we're sure whether they're 100 years old or not? There's infinite scope for litigation about the meaning of some of these phrases. Anyway, that's the broad list, and we have this absolute ban on the import of things which were illegally excavated or illegally extracted. Then we move on to Articles 4 and 5. I'm going to cut. There's some. Let's do. Yeah. So basically, the ban is you can't do any of those things. You can't, in those circumstances, you can't import anything unless you can get, as regards the things listed in Part C of the Annex, you need an import license, and as regards the things in Part C of the Annex, you need an import license. That's what we're going to get to. So for the things in Part B of the Annex, and we'll get there, what you need is an import license issued by the competent authority of the member state in which the cultural goods are placed for the first time. So the member state into which one is seeking to, the first point of contact into the EU, effectively, the first point of real contact, the import, that country needs to give an import license. And the things which fall within that regime are the ones in Part B of the Annex, which is just two categories. So products of archaeological excavations or of archaeological discoveries on land or underwater, and elements of artistic or historical monuments or archaeological sites which have been dismembered. So, as I said, looking at the preamble, the core focus of the regulation seems to be on basically archaeological or excavated materials, and that's the Part B stuff. And if you want to export that into the EU, you need an import license from the country into which you're importing it. There's a lot to say. The first point is that Article 4 uses the word import, whereas the general prohibition in Article 3, the basic rule, used the word introduction. And there's some guidance from the Commission which makes clear that those words are indeed meant to have different meanings. So one has to pay attention to whether you're trying to introduce something which triggers Article 3 and is a relatively broad word, or to import it, which is a narrower concept, and the guidance explains what the difference is. In which case Article 4 might be relevant, but those are different words with different meanings. How do you get an import license for these sorts of goods? What you have to do is to prove that it doesn't fall within the prohibition, i.e. it wasn't unlawfully excavated or it wasn't unlawfully exported. And we see this is Article 4 sub 4. The application should be accompanied by any supporting documents and information, providing evidence that the cultural goods in question have been exported from the country where they were created or discovered in accordance with the laws and regulations of that country, or providing evidence of the absence of such laws at the time they were taken out of its territory. So what matters is the law of the state where those goods were at the moment of export, which, that may depend if you've got states on shifting borders. You've got to find out the date first, then work out into which country's laws, within which territory, within which state that territory lay at the relevant time, and then what was its system of law at the relevant time. If it had an export license regime, can you prove you had the relevant export license? That is obviously fiendishly difficult in a vast number of cases. There are any number of states which, for very good reasons, now have prohibitions on export, now have patrimony laws, which either didn't in the past or which didn't enforce them very clearly in the past, or which simply didn't issue the relevant paperwork, or the paperwork's got lost. It's perfectly possible that something was lawfully exported in 1924, or even 1984, but where perhaps because there's been a series of sequential sales after that time, the current owner doesn't have a piece of paper that can prove that they had an export license. And I'm going to talk about lots of other things, but basically that problem, what I'm going to say, that problem is never going to go away. That evidential difficulty is just massive, and it's going to prove a huge burden for many people who want to import things. There's a couple of derogations that try to make life easier. One is where the country where the cultural goods were created or discovered can't be reliably determined at all. You just can't know where it's from. In which, I'll get to the second one first. The second one is where the goods were taken out of the country where they're created or discovered before the 24th of April, 1972. And the relevance of that date is it's the date of the UNESCO Convention. Now, this is an aside, but I find that really interesting because the UNESCO Convention is often thought, a lot of people act as if in general in the marketplace, as if 1972 is some sort of stop date, and anything before that date can be traded freely because it's sort of, that's the date when the UNESCO, that's not true. The convention doesn't on its face actually give any form of protection for pre-72 exports or excavations. So this, as far as I'm aware, is the first time that there's actually a piece of legislation which enacts that UNESCO date as which puts into statute that date as a sort of protective date, because the convention itself doesn't do it on its face. The market has kind of interpolated that protection. So I find that quite interesting. In both of those cases, yes.
A minute.
Oh gosh, okay. In both of those cases, what you can do is instead provide evidence that whichever state the object has resided in for the last 5 years, for the last one in which it resided for a period of 5 years or more, if any, it was exported out of that state lawfully, if you fall within one of those derogations. Going to be a long minute. The category C is a whole longer list of things at the back of the regulation, which is various other pieces of art, antiquities, ethnological interest, artistic interest, and so on. But the long list we saw in A, which falls within the general prohibition, not everything in B and not everything in A falls within one of B and C. There are some things which fall within the general prohibition in A, but which don't fall within either of the licensing regimes. So they're just within the prohibition if they're illegally exported, and that's the end of it. You don't otherwise need some sort of license. What you need for C is not a license, but just an import statement. So you, as the importer, give a sworn statement that it was, for example, lawfully excavated. But it's probably going to be a criminal offence in most member states, or in all member states, to sign such a declaration if it's false. And it might be extremely hard for you to know that an object was lawfully exported if it was, some time ago. The same two derogations apply, so it's a bit easier for pre-1972, but you still have to show that the thing was exported pre-1972, and that may itself be very difficult. Okay, there's any number of problems, so let me raise one, which is, imagine you don't get a license and you import the object anyway, and it isn't initially caught because, for example, one question we have is how well will this be monitored and enforced? So imagine it's not initially enforced. What then will be the effect on a third party who in good faith purchases this object within the member state sometime down the line? Are they liable to have that object seized because it was imported into the EU in breach of this regulation? It seems to me quite possibly, notwithstanding they're a good faith purchaser. Will they find themselves effectively unable to sell the object because it has subsequently been discovered that it was exported in breach? Again, it seems to me very possible. So real risks for third parties, I think real difficulties of meeting the evidential burden of compliance. To close, great intentions. Clearly, it's a market that can have problems which deserve to be thought about. But the real danger, I think, is that all the illegal exporting which currently happens will continue to happen without the criminals applying for applying for permits and so on continue to operate underground or operate not through the EU but through other jurisdictions. Whereas the lawful, good faith market participants will now comply or seek to do their very best to comply with this regime in a way that is extremely burdensome. And I think that's going to be very difficult. All I will say then is there's this guidance which I really recommend reading through. Questions and answers document which you can find online, which includes a couple of examples at the back. They're good.